everyone, welcome to Talk It Out Tuesday with Attorney Roberts, where we take complex legal issues and simplify them. As a solutionist, strategist, and simplification specialist, I love taking complex legal issues and breaking them down into more digestible bites. The Bible tells us in Proverbs 4:7, in all you're getting, get understanding, and that is exactly what these Talk It Out Tuesday clips are designed to help you do. Today, we go back to one of my favorite areas of law, which is contracts. And we are specifically talking about the 5 types of agreements that have to be in writing in order to be enforceable or actionable in a court of law. So, the first contract that has to be in writing in order to be valid or enforceable are contracts in consideration of marriage, right? So I know we sometimes call people our spouse, but if it's not in writing, it's not valid. It's not real. Just saying. And then the second type of agreement that must be in writing in order to be enforceable in a court of law are contracts that cannot be fully performed in 1 year or less. So if, for example, we are making a contract 2 years in advance, this is something that by default cannot be fully performed in 1 year because we're 2 years ahead of when we're looking to actually perform. So this has to be in writing, and that offers some protection because 2 years in advance for something leaves a lot of time for things to be forgotten, details to get fuzzy, especially if there's back and forth about the details. It just makes a lot of sense to capture the details in writing at the time of agreement, even if it's a few years in advance. The third type of contract that must be in writing in order to be enforceable are land contracts. So anything for the sale of land or anything dealing with improvements or anything related to land must be in writing. The fourth type would be ones where someone is designating you to be the executor of their estate. The next agreement would be ones for the sale of goods in excess of $500. So if we're talking $500.01, that has to be in writing. If we're talking $499.99, that can be in writing. It's not mandatory, it's optional, it's a good idea, but it doesn't have to be in writing in order to be enforceable if it's under $500. The next agreement that has to be in writing, and this would be the last one, are agreements where you agree to be the guarantor for someone. These are known as suretyship agreements. So if you agree to pay or answer for the debt of someone who is unable to, that has to be in writing, and this again offers some protection so that other people's debts are not just being pinned on you. So just to recap, the different types of contracts that have to be in writing in order to be enforceable are ones in contemplation of marriage, ones that cannot be fully performed within 1 year, ones for the sale of land, if you are an executor of someone else's estate, sale of goods for more than $500, even if it's just 1 penny, and lastly, the guarantor or suretyship of another's debt. Thank you so much for tuning in. We will see you next time, hopefully next week, Lord willing, with the technology. And if you should need any questions answered or documents reviewed, or we can be of any service between now and then, visit us at www.reviewedbyroberts.com.